I would like to. I mean, we are going to focus on basically two different topics. I mean, geographically speaking. So one will be China, and the other one will be South and East Asian countries, which is a little bit tricky because it's just a region, and economically sort of homogeneous or looked at just one economic zone. But from the legal point of view, it's very diverse. So each of those countries that we are going to talk about has some totally different legal system and different legal tradition, and even though they have different solutions for protection of intellectual property, you will see some similarities, and you will see that they are coming from basically the same needs and the same needs in terms of economic development, and the same answers in terms of legal system. How do I change the slides? Probably, yeah. Okay, so both hands will be busy. So scroll. Okay, that's yeah. The title is sort of obvious. So it's about protecting what is the most precious for a company in the modern world, which is intellectual property, which is your technology. A few words about myself. I studied in China, and it was a long time ago. But still, my interest in this country goes back to mid-90s. And when I was a student in Poland, I also had a chance to work on a number of projects in Asia. I mean, as a legal advisor. I studied in Poland and the US, and have, I would say, particular interest or focus on intellectual property, but not only. I was doing a lot of work in M&A and oil and gas, infrastructure projects, and direct investments in China and some other Asian countries. As with regard to the intellectual property, I'm mainly so I'm not a patent attorney, and I mainly work on the transactional side. I never do patent prosecution in Asian countries. It's rather about negotiating technology transfers agreements and providing clients with advice as to their strategy, their overall idea how to protect their IPR related assets when doing business in Asia, and in particular China. If you feel any need to ask me for some materials, ask me any additional questions, please feel free to drop me an email. It's pretty easy, just like my name and surname and then PL. So what we are going to talk about, at least in the first part of our seminar, is first just overlooking the legal systems, then introducing basic concepts of intellectual property, and you will see that, well, I think I have no clue how intellectual property works in Croatia, but I think it will be similar to any other European country, including Poland, because we are part of the EU, we are part of the WTO, and we are parties to the Berne Convention. So there will be similarities, and you will see between where I'm coming from and what I expect Croatian law is about. But what might be surprising for you, I mean it was surprising for me, is that even though they are coming from different tradition and different historic background, the particular regulations in the IPR area are kind of similar and easy to understand. So what is difficult, what might be surprising, what might be tricky is in the details, not in the general ideas. Then I would like us to talk about the IPR regimes in a number of countries and focusing on main areas like patents, copyrights, trademark, and trade secrets. Trade secrets are usually, it's like smaller siblings, smaller brothers. So people don't really think about trade secrets, or often don't think about trade secrets when they are thinking about protecting their IPR. It's rather copyright or patents, and people are more focused on registering their patent, registering their trademark, which is good thinking. But also trying to rely on either contractual protection, and I'm talking here about confidentiality agreements and non-competition agreements, but also on the legal regulations on in the area of competition law and unfair competition. That can be quite effective measure to protect your IPR, your technology, or your business methods, your confidential information when dealing with business partners in Asia. And then some practical tips, like what might be a good idea to do when dealing with Asian partners, in particular Chinese partners. And then introduction of our two help desks, the IPR SME in Beijing and Jakarta, and introduction of what we do and how we can help you, what kind of assistance we can offer. So this is some basic information about the Association of Southeast Asian Nations. As you see, this is quite a big chunk of Asia in terms of territory, in terms of the population, and also economy. It is also one of the fastest growing areas in the world. And Southeast Asia is becoming more and more important in trade relations with Europe, with the European Union, and it also becomes more active internationally or in the international economy, not only the particular countries, but also the organization itself. So I think that the idea behind forming the Association of Southeast Asian Nations is to create a common market. So it's very much like European Union or 200 years ago, the United States. Probably European Union is more similar in terms of diversity, of linguistic and geographical diversity than the US. Nevertheless, the idea is to have basically not only free trade agreement, not only free trade zone, but to have also so it's not focused only on the relations among those countries, but also on the external relations. So how the ASEAN are treated in their relations with major trade partners, and that they are negotiating the trade agreements and investment protection agreements on behalf of the organization, not on the behalf of the particular countries. Another side of that project is that not only investments within this zone and the free flow of goods are the objectives here, but also creating one homogeneous market for the capital and for the workforce. So I think the region will be evolving into something more than just a trade union, and even though it's always tricky to look look at the region, and that makes us making some generalizations which might not be accurate. I think that that we are looking at something new in terms of quite a huge market, rapidly changing, rapidly growing, and which will get more and more attention around the world, and which will get more and more influence economically and politically. As you see, those are, countries which are members of the association are quite diverse in terms of what we think about Laos, Vietnam, Cambodia, and Burma compared to Singapore or Malaysia, for example. So you will see quite big differences in their economy, but also in their regulatory framework, in their law. You will have a great, very mature legal system in Singapore, for example. You will have quite a good system, working for something between 50 and 100 years in Thailand. Very stable legal system, or Malaysia, and you will see sort of developing or not that mature systems in the countries which went through or going through a transition. I'm particularly thinking here about Vietnam, Laos, Cambodia, and naturally Burma, Myanmar, and that will affect very much, how to what extent you can rely on the legal protection in those countries, what you can expect, and what quality of protection or enforcement you can get there in terms of protecting investment, your company related rights, your rights as a shareholder or a director in a company, but also competition law and intellectual property. There will be, what I'm trying to say is that even though you may look at this region as one market, then you should be aware that there will be differences in how helpful the legal system is in those countries, depending on their heritage. Right. China is, I think, a region which doesn't, or a country which doesn't need that much introduction as the Southeast Asia. It has been first it's been a booming economy, and what was in particular impressive and surprising was that this booming economy came out of nowhere. It's turned out that the economic reforms of socialist or communist regime were successful in creating a market economy, and this market economy proven to be very competitive internationally. So if you look at what happened in China over the last 20-30 years, you can easily see how the role of the country and the role and the stages of which the economy went through were changing. So first we were thinking about, or we were facing struggling economy, struggling for resources, struggling for capital. Then it was the factory of the world, and now China becomes a primary source of capital, of investments, and also focuses not that much on heavy industry, on low margin industries, on basically cheap production, but rather on sophisticated technology related areas, and you can see for the last couple of years 5, maybe longer, that some other Asian countries are competitive vis-a-vis China in attracting capital and in attracting investments in those areas which were very much which were predominantly Chinese, as the footwear, clothing, heavy machinery, manufacturing, etc. So what I'm trying to say is that you can look at China as more mature than other countries in Asia, and what you can also see from the perspective of European investors is that they are less focusing on producing in China and exporting the products, but rather on working or focusing on the domestic market, both business to business market and a consumer market. And this is the result of the development of Chinese economy. Still, so it's in a sense it's becoming more and more attractive, but in a different way than it was attractive 10 or 15 years ago. And when you're thinking about entering China and conducting business there, you are thinking about different issues and different way of protecting your interests and your assets than you were doing that 10, 15 years ago. As to the Southeast Asian countries, as I said, they are diverse and they are growing, and you will see much more opportunities in actually relocating your joint venture companies in 1978 and 1979. There was nothing. Basically, if you look at your daily life, if you look at running a business, you can. It's sort of like in the back of our heads that the legal system, the legal issues they are surrounding us. And now try to imagine that it didn't at all exist in China for 30 years. Of course, this is part of the communist heritage. The country was run in a different way, but it's kind of helpful to understand how new to your Chinese business partners, to average Chinese people, including managers, including government authorities, the concept of law. Something which is really so natural and so embedded in our thinking about the society in Europe, that social relations, economy, it's all regulated somehow. And this regulation can be easily figured out. You can find the actual rule that applies to your situation. and you can rely on it. You can predict how how the law will impact your business, and you can predict to some extent what is the right thing to do and what are the risks of transactional, and what are the risks if you're entering into a dispute. And to some extent, you can rely on the government as the arbitrator, as the dispute resolution forum. So I'm trying to say that you can go to the court and have your dispute figured out. You don't really have this thinking in China. I mean, you do, because they do have legal system now, but it's just one generation. So it is striking when you're talking to Chinese business people, and it was even more striking some time ago, like 10, 15 years ago, that they do tend to rely on something else than law, which can be tricky, which may mean that they will be reluctant to sign a proper agreement with you. Or on the other hand, they will be very happy to sign whatever you want them to sign, and they will just disregard it. To make things more complicated, you have a sort of like new young generation of Chinese managers and Chinese lawyers, and they have the whole their life is interacting with Western investors and interacting and living within a country of modern economy. So they might have an approach which is similar to ours, and then figuring out with whom you're talking to and what you should focus on, like relation building, or basically focusing on the contractual documents, then that might be a challenging task for you. If you look at the Chinese legal system, it's very much economy driven. So it was created, and it's been developing to answer the need for market economy. And the Chinese government, they realized back in 1970s and 1980s that you can't have a successful economy, and in particular, you cannot attract investors if you don't have a legal system. And when you look at what was regulated and when, you can see that domestic laws, I would say that the laws that regulate everyday life, they were abandoned until mid 1990s, as opposed to legislation which was focusing on companies and investments and contracts, and to some extent also intellectual property, which came into play in the early 1980s. But if you would remember one thing from today's seminar about China, is that the law is very new there. It's been around for 20 years, 30 years maybe. So they have different background than you do, because for you law was always around. 100 years ago you had property and contracts and company law, and that was the same 200 years ago. So you really had always something to rely on to find a rule that will regulate a particular social or economic activity. Market reforms, that was the engine driving the development of legal system. That also meant that how they were creating their legal systems, they were basically relying on what the Western world came up with. So you will see a lot of sort of legal transplants in China, and there are two streams, I would say. The first goes over 100 years ago to the first Chinese Republic. So we're talking about years from 1911 to 1930s. And that was like the first wave of modernizing Chinese law. Then it was totally abandoned. But this thinking, how we approach that, it stayed. And that was either done, and the Chinese, the government, they were asking these questions as it was asking many other Asian countries, including Japan. Where do we borrow from? which legal system we like more, American or English, and American and English, or continental Europe like France and Germany. They decided on France and Germany a little bit under the influence of Japan, of the Japanese lawyers, which translates into very funny or like very surprising phenomenon when you actually dig into Chinese private law, like contracts law, that is very similar to, for example, Chinese law of obligations, Chinese. That was the most striking. The civil law. It is very similar to what we are used to in Europe, in our part of Europe, which is related to the 19th century German thinking about debts, receivables, the very basic institutions of civil law. But I'm digressing. I guess it's not that important, probably. So they were borrowing back in the 80s and the 90s. They were following examples, following the leads, the tips from Western countries, the US and Europe. In the company law, securities law, the areas that regulate the life of a company, mergers, this sphere is more similar to English and in particular the common law system, and particular American. If you look at the other spheres like intellectual property in particular, but also contracts, civil law, it's more similar to Europe. So you will find yourself when you actually read Chinese laws, they are similar to ours, and that can be misleading. And I will tell you in a moment why that can be misleading. Intellectual protection, that was introduced, as I mentioned, pretty early on. So the first regulation on copyrights was 1982. It wasn't very good, and it wasn't very good from our perspective, like how well it protects economic rights of the creators. But that was just the first step. That was the first regulation on in the Chinese history relating to protecting the IPR. Historically and traditionally, Chinese society, Chinese thinking is not, I would say, very individualistic. It's rather focused on the society or on the group, and thus our notion, European notion of protecting the rights of author or rights of the inventor or creator, especially moral rights. The link between the individual and his or her work were kind of foreign to China, which translates that into that if you copy someone else's work, if you combine it with your own work, if you rely on others, it was, and to some extent it still is, socially acceptable in China. So the whole concept of IPR and connecting some being proud and being linked with the product of your intellectual process, it's one thing, but utilizing that to your own economic benefit as opposed to benefiting the group, the society, is something quite new to Chinese philosophy or thinking. It is changing though. So China is more and more not only open to protecting IPR, but due to the shift in the economy, they are more and more relying on IPR as a source of wealth, as a source of competitive advantage in the companies, etc. And you will see a trend, for example, in patent applications. There is tremendous growth of new patents being registered in China. over the last 10 years. And if you look at the domestic companies and the foreign companies, they are doing more or less the same for the last 15 years. So there is steady flow of patent applications, while the applications from Chinese companies are skyrocketing. What is even more interesting, Chinese companies started to apply for patents or to seek patent protection elsewhere, in Europe and in the US. You can see a trend of growing numbers in patent applications from Chinese companies relating to their inventions, to their technology protected elsewhere, protected in Europe and the US and the like primary markets. And you can see Chinese companies being more and more successful in saying their genuine technology and protecting their technology that is disputes. Mainly in the US, patent disputes, where the Chinese companies start to, from time to time prevail in those disputes. So that also changes the mentality. If you can see that IPR protection is not only about the foreigners trying to force you to follow their rules, but it is beneficial for you, that this is a major shift in thinking. And this is what we are facing now in China. So I'm quite optimistic as to the quality of the improving quality of IP protection in China, which results not from the Chinese government being particularly generous to the foreigners or to the inventors and authors, but from this shift in economy. If we look at the Southeast Asian countries, again, very diverse, and that comes from the history, that comes from their heritage. You can see countries which are basically common law, which follow the British and American legal tradition, which relies not really on the statutory law, not really on the acts of parliament, but rather on the custom and the decision and the continuous decisions of the courts. So this is the common law, right? That is, you could think at it. You can think of it as customary / judicial driven law. So decisions of the courts, they tell us what the law is, not really the parliament, not really the laws that are written and passed. Of course, nowhere in the world there is this pure common law system. So even in the US and in the UK, the statutory is more and more important. You can see that at the same time in the continental Europe, like our countries are traditionally civil law systems. So we depend very much on what the parliament, what the legislator is telling us the law is. This is basically it. So you look at the piece of legislation and then you find out your answer. In our countries and in the European Union, basically, and in the civil law countries, you can see more and more or growing importance of the court decisions. So you can't really work and tell what the actual rule is if you don't analyze what the Supreme Court in your country, the Constitutional Court in your country, and the European courts EU courts are telling you the law is. So we more and more, we kind of like getting closer to the common law system, that we more and more rely on the interpretation of the law. And you can see a lot of judicial activity. China is a civil law system. It's very much driven by the will of the legislator. Who is the legislator is a little bit tricky, because then they don't really follow this also very traditional, very European way of branches of the government. So you have separate legislative, separate judicial branch, and separate government, the executive branch. Executive and legislative are sort of, or the executive also has a lot of power in the legislative, in passing the legislation in China. So you will have, and that is also a little bit difficult for us to understand, that you will have quite a lot of power in terms of passing the laws, which is vested on the government. So coming back to the Southeastern Asian countries, you have purely civil law countries like Vietnam, for example. You have purely common law countries like Malaysia, socialist law, Laos and Vietnam. So that will be. It comes from their history, their heritage, the last couple of decades, where their political system was very much twisting or shaping their legal system. And you have an important factor that is local traditions, and this is especially in Indonesia. They are very diverse. I mean, as a country, if you try to trace where the regulations are coming from, is there anything in common in those countries? Yes, they have. The bottom line is that their legal systems come to the very similar standard of protection, very similar conclusions in the central values or values surrounding the market economies. It's like in China, but it's done usually better or in a smoother way. They are very much, their legal system, they're very reliable as to the protection of property, protection of investments, freedom of contracting, quite a good quality of the judiciary. Comparing to China, for example, they are very, because this is association of countries, and because these are economies that started to cooperate among themselves, they are very much oriented into the international trade, into no barriers in the international trade. And this thinking also applies to their external relations. So as they wanted to trade between themselves, they are also open to, they are also quite welcoming to the idea of opening their market for imports. Unlike China, China would be very protective in terms of relations with external countries, with imports, and quite liberal labor market in terms of flexibility of labor relations, so that you can basically easily employ your workforce and easily dispose, easily. You don't really. It's sort of like opposite to European or Scandinavian model, where looking at that from the other perspective is that you don't really have strong protection of employees in Southeast Asia, generally speaking. If we look with a little bit of detail to those countries, they are. I mean, it's self-explanatory, as you say. It's very much driven by the history. Indonesia, which was under the influence of the Netherlands, which was a Dutch colony for quite a long time, their law is very similar to Polish law, I would say, when I'm looking at their legislation. And the similarities coming from that both Polish and Dutch law is similar to German law, which is really strange. I mean, which is a strange feeling when you are looking into such a faraway country, such a different country in terms of everything, of their tradition and history and their original culture, that their contracts are regulated in the same way as in Europe. The IP law is basically very easy to understand for us, and that is, well, IPR was never regulated in Indonesia before the first Dutch regulations, and the first Dutch regulations it was the late 19th century. So so they were following more or less the same development of the intellectual property law as in Europe, up to more or less their independence, which is 1940s. Then they picked up again in the 80s and the 90s. And they have quite a modern, easily understandable, reasonable system of IPR protection, quite reliable judiciary, quite transparent system. If we look at the different areas of Indonesian law, it's very it's like a maze. You have very strong position of the provincial legislators and governments. So you will have a different in terms of administrative law, in terms of zoning, of how you can use the land, of how you apply for licenses for different business activities. Then you will see changes, not changes but differences among the provinces. You will have but this relates mainly to family law, to inheritance. These areas which are not really interested that much in when you're foreign investor or when you are a business partner, when you're dealing with technology. But they are coming from a tradition which is very based on the customary law. So there was this layer of Dutch law for a couple of 100 centuries, which first didn't really apply to the locals. And then it was, more and more popular in the sense of applying to all the citizens. But originally, most of everyday life was regulated by the customary law, and this customary law, which is called adat, it's coming from some Javanese language probably, which was then codified. So you had codifications of the customary law on different basically islands in different provinces, very much different. And the Dutch, they preserved the system. They were thinking it's working fine. Why to change it? So it is still there, but you are it's very unlike that as a European, as a foreign investor or manager working in Indonesia, you will ever have anything to do with that. Islamic law, it's also one of the elements of this legal puzzle in Indonesia. Mainly family law, which doesn't concern foreigners or foreign investors, unless you have a family there, with one pretty big carve-out, which is financial system. Islamic banking is very strong in Indonesia. It's one of the biggest, Indonesia is one of the biggest Muslim populations in the world. Maybe it's the biggest. So when we're thinking about Islamic law and Islamic finance, we are usually thinking about the countries like United Arab Emirates or Saudi Arabia, etc. The biggest market, at least for the financial services and customer-oriented financial services, is Indonesia. Again, it might affect your investment in Indonesia if you're seeking local financing. So what kind of bonds you can issue, what kind of loans you can get. That might be tricky. That might require some expertise and some thinking about it. It's not that. It's not impossible. It's you can figure it out. It's just different. But if you're purely coming, with your own financing from Europe, or if you're just trading with Indonesians, or you transferring your technology, you're producing somewhere there, you don't really have any interaction with these unusual, I would say, areas, unusual pieces of law. Malaysia, former British colony, then common law system, strong role of judiciary. You might have areas of law which are not regulated in the sense that there is no legislation. For example, unfair competition, the protection of trade secrets in Malaysia. It's based on the customary law or the judgments, and there is no piece of legislation to cover that. So that might be a little bit tricky. Which also might be tricky for people coming from our part of Europe, is that they follow the English and American system of company law, and the basic difference is, there's a number of differences. It's more flexible in a sense, but the most striking difference is that the governing and supervisory body is marriage, is the same. So you don't have the supervisory board and management board as in Germany, Poland, and I believe also in Croatia. You have just one board of directors, and they are executive and non-executive. But it works nice. IPR, similar to English law, you will be very. The concepts and the way they approached IPR is very much driven by the influence that the English had. Thailand. This is an interesting jurisdiction. They had this discussion in the beginning of the 20th century, which way to go, English American or European. They decided on following continental civil law tradition with some exceptions, because for some time, for example, they decided that the rulings of English courts will be the source of law initially. So and they still have some areas which are very much common law, in the sense that you will see unrecognizable ideas or institutions, for example, in a real estate, which very much resemble old English law or American real estate property law. Also, companies are regulated based on the American model as the company law in Malaysia. But those those differences, they are not. It's something that you can. There will be a difference. There will be something unexpected, but it's well described. It's well developed, and it's understandable. So you won't have any problem in figuring out your way. Vietnam is kind of tricky. It's similar to China in the sense that it's a communist country, or it's country in a transition, market economy, not that much political freedom. The government decided to go into the market economy and free economy because it's basically in their interest and the interest of the growing country, but it's not combined. When I, for example, compare my own country with Vietnam, in Poland, the economic reform and political reform, they came at the same time. You don't see that in Asia. And I think that this is a quite profound difference between Europeans and Asians, that they are more focused on economy and the free market, and how they are able to freely contract and shape their business activities, and less in political and civil rights. But that might not be. That might be just a discriminatory oversimplification. It's hard to say. But if you look at how it works, you can have free market economy in Asia without political system that would resemble democracy. And this is also a case of Singapore, to some extent, or historically also Malaysia and Indonesia. And the Vietnamese law is very much similar to French, which is, again, quite no surprise, taking into consideration that they were a French colony, which is interesting. They didn't, as opposed to China, which basically quashed, like deleted all the legal, any regulation in 1949. So basically everything was pronounced invalid, proclaimed invalid. There was no regulation. The only thing that needed to be regulated, if, for example, if you realize that there was no criminal code in China between 1949 and 1982 or 3, I don't remember the exact date, but you have a gap of 30 plus years where you have no criminal law, no criminal code. And you still had criminals, you still had criminal courts, to adjudicate. So the only, for this 30 and something years in China, the only piece of legislation that was in place was family law, which was dealing with the marriage, divorce, and the child custody. It was something that they decided makes sense to have, and they introduced this regulation in the mid-50s. Vietnam, similar situation, but totally different answer. They left most of the French law in place, and they were building on that, even back in the 60s and 70s. Okay, now we have a good understanding of legal systems in the countries in question. I would like to cover with you the basic ideas of intellectual property, like what it is. It might be too, oversimplification, or it might be too, might feel obvious to you. Nevertheless, I think it's worth to like map the area, like map the territory, which we are focusing on. Intellectual property rights are very special if you look at them in the context of the legal system. They have like twofold nature. The one is personal. It's like personal link with my creation or my invention, which is called moral rights. So this is about putting my name on my work and protecting the integrity of my work. So even if someone pays me, even if someone is ready to pay me for using my novel, using my song, I may not be happy with them transferring it, changing it, altering it, right? So we're looking at that as a sort of maybe not emotional, but some private, personal relation between the creator and the creative work. This is very much European way of thinking. It's not that strong, for example, in American IP law, where the protection is basically focused on the economic rights. So as long as you pay me, as long as I'm getting remunerated, you can do with my work whatever you want, once I allow you to do that, and I'm not getting paid for that. In Europe, some of the moral rights are not transferable. For example, you cannot basically you cannot assign to another entity the right to claim to be the author of a right. You can withhold, like you can oblige yourself to withhold, exercising this right, but it's not transferable. So exclusivity. If I wrote something, if I created something, I'm rewarded, or on one hand I'm rewarded for this creative work as being the only person who can use it, or the only person who can decide how to use it. But I'm also expecting that this is mine, that this is going to be, this link is so strong that I should be in charge. It's intangible in the sense that it doesn't exist in the material world. I mean, it's not an object that you can, touch or feel. It's sort of tricky because usually you need some tangible form. The creative work that never was shown, never was transformed into a physical object or source code, computer in terms of software or a writing. I mean, something that does exist in a physical world, then you don't really have IPR protection. When you're a technology company, it doesn't really make much difference for you. It's more like, those questions are not that practical. If you look maybe at choreographic works, at dancers, like traditional knowledge, like the knowledge which is passed, mouth to mouth, basically. Traditional healing in Asia or other places, which are not really written, which do not translate into any physical objects. Then you have a discussion like, is it protectable or not? For us, not that important. You will have either a piece of writing, a sketch, and prototype. There will be something that you can show. This is what I worked on. This is how it looks. This is how it works. This is the idea behind that. And intellectual component is that for IPR protection, you need to show that it's the product of your creative process, of your thinking. You can't take an object, you can pick up a stone and say, this is creative work. I created that, and that's why it should be protected, and no one else can, look or sell or use similar stone. But if you arrange objects in a specific, creative, original way, even though it's not really appealing to anyone's taste, then you can get protection. The very good example is protection of photography, protection of pictures taken by photographs. When photography was created, it wasn't considered an art. It was just mechanically registering physical objects in the world. So painting was protected. Photography, not that much. But then it changed in early 20th century, mainly in America. Like that was the this shift of thinking was driven there. You could see that some photographs were starting to get protection, and this dividing line was: is it original? Does it look at the reality in an original, new way? Is it just simple snapshot, or is it arranged nicely? Did it require to wait for the special light? Did it require a special arrangement of the objects, etc.? So this intellectual component can be very small, I would say. It doesn't have to be. Recognized by others as something nice, interesting, intellectual, appealing, whatever. If you just prove a little bit of originality, a little bit of creativity, that's enough. So this is the framework. If you look in more specific way, like what are the intellectual property rights, it very much depends on what activity you're dealing with. Science and technology, that will be patents. And to some extent also protection of trade secrets and competition law. So basically your technological solutions, your inventions shouldn't be utilized by others without your consent. If you look at the arts, that will be mainly copyright. Copyright, which applies to literary works, musical works, videos, cinema industry, but also in most of the countries to software protection, which is kind of tricky because the basic idea of copyright is like it prohibits one-to-one copying, like taking exactly the same thing. You are allowed to, as a general rule, you are allowed to create derivative works. So use something that was created by someone else as a starting point from your own creative process. With software, it's very tricky because you don't really, I mean, if you are extending some protection, it's not about copying the 100% of the source code. It will be rather about using the same ideas, using the same algorithms. And copyright, I mean, there's this dispute, like which branch of IP law is better in protecting software? Is it copyright or is it patent law? And all the countries in question, they go for the copyright protection. Like the only major jurisdiction which applies patentability of software is the US. But since it's so big and so important, it can't really be ignored. The last thing, market identity. This is how we are offering our goods and services. This is how we present ourselves in the marketplace. And this will be based, I mean, protection of your logo, of the visual aspects of your goods, trademark protection. To some extent, some logos can be protected under copyright, but registering a trademark is the first step if you want to show your product on a particular market. Now, this is a little bit confusing because some of those rights, they require registration. So if I invented something and I do not register it as my invention, then I don't have any protection. On the other hand, some, for example, trade secrets, I don't register it. I don't really disclose it to anyone. This is the very idea that I keep it secret. With copyrights, creation is the starting point where the protection appears. So once I publish it, once I disclose it to others, then I'm protected. But most of the countries in question, including China, even though they do not require registration, and again, one of the only jurisdiction that required registration until late 70s, I think 1976, was the US. So they had this system of registering works to be copyrightable, and they abandoned that when they joined the Berne Convention. Then there's this question whether it makes sense to register copyrights. There are two arguments why it makes sense. I mean, from a practical point of view, it's so much easier to prove that you are entitled to protection in the court. And my advice would be always register, or always get as much registration rights as possible in China and other Asian countries, because then from the evidentiary point of view, it's just easier for you to prove this is mine. I brought a copy of my work, I registered that with the Copyright Office. Another argument, more, I would say, sophisticated for registration of copyright, but then it would need to be obligatory, is that sometimes it's very difficult to figure out who has the right to a particular work. So you have this term of orphaned works that you know that they are protected. For example, this is mainly publications and early movies. like the movies from the early 20th century, you know that they are protected because the protection extends usually 50 to 70 years after the death of the co-author, and in case of movies you have a number of potential of the copyright holders, and with less popular, same thing with music, with less popular works you might not be able to find the copyright owners, which are whoever the rights passed on to under the inheritance rules, and then you prohibit it from, for example, publishing it. You cannot show some old movies in a theater and the TV because you cannot figure out who is the owner. You cannot publish some books because there is a risk it's still protected. You don't know if there are any owners, and it will be too expensive to find them. So, to some extent, it makes sense to ask the owners of copyrights to come once, every couple of years, and say, yes, we want protection. Because then, if something is not registered, it's in the public domain, you can use it. So life would be easier. But that's not the reason why China, Indonesia, Thailand, and Malaysia they use the registration of copyrights. It's only for practical matters. It's not required, so you still have protection. It's just easier to prove that the particular thing belongs to you. What always have to be registered? Trademarks, patents, design, industrial designs, and utility models. So your visibility, your market identity requires registration, and your technology. There are two issues I would like you to consider, to think about when talking about protection of technology. The very basic idea of patent law is opening up, like sharing with the public, what is your technology, what is your invention. So a proper application for a patent should have a description of the technology or of the product or of the process, and that should be detailed enough so a specialist in the field, in this industry, can actually, following your description, can come to the same effect, can follow the same process or create the same product. Why is that so? The idea is that the inventors, they should be contributing into the development of science and technology. And they are incentivized to do that, to disclose their technology, to disclose the result of their intellectual activity by giving them right for exclusive use. So, in exchange for me sharing with everyone the invention, I have the right to use it for the first 20, 30 years. So nobody else without my approval can benefit from industrial application of the technology. So it very much makes sense to register a patent if we want quite a strong protection, but for limited time, and we cannot, or we are afraid that without this protection our product, our process could be copied, could be followed. If we don't have this fear, so if our product cannot be reverse engineered, if it cannot be dismantled and analyzed, then do we really need patent protection? Probably not. And this is the kind of like dividing line. If we go for the patent protection or we rely on trade secrets. As long as our product is not at least easily reverse engineered, then we don't really need this patent protection. We can do better without without disclosing, without this obligatory disclosing of how it works, and as long as we keep it secret, as long as nobody learns from us or from just analyzing the product or the process, then we are protected. And this protection is unlimited in time. Very good example, like very well-known example, is the formula for Coke, for Coca-Cola. If they patented that back in 19th century, it would have been in the public domain for over 100 years. And they would need to do what pharmaceutical companies do. Change it, alter it, develop it. I mean, keep on top of keep transforming the product, which is very difficult when you're talking about something that people got used to it. I mean, a particular taste that, that goes for generations. Of course, there are, it's oversimplification because this taste changes, but it's amazing that you can keep something as your intellectual property for such a long time. There are two conditions, though. First, you need to keep it secret. So once it's disclosed, once the public knows the secret, then it's not a secret anymore, and it's not protected, because anyone whom you would charge with infringing your trade secret might say it's already public, it's already known. So I didn't steal it from you. I just took it from the public domain. The other thing is that is it difficult enough to recreate or to reproduce the product with apparently with a secret formula? It's not that easy. I mean, you can get pretty close to the taste, but you cannot really claim that it's the same. With most of the inventions, it doesn't work that way. I mean, if you have a skilled competitor, if you have a skilled scientist, they would be able to analyze and figure out how your inventions work. And that's why you need patent protection. And you need patent protection as soon as possible, so your product doesn't hit the market and doesn't open a time window for others to copy it. If there is no secret part, if there is nothing, if your product, it's usually product, not the process, because I mean, with the process, industrial process, you can more easily keep it secret, you can keep it confined. But with a product which you offer on the market, if it can be reverse engineered, then it's not secret, right? There is no, you can't claim it's secret, it's confidential. And then you won't have protection under any trade secrets laws. Another thing which is quite important to remember is that the registration and protection is territorial. So registering a trademark or patent application in one jurisdiction, usually, I mean, it's not that simple, but because it might give you priority rights or a window of time window for like using your initial registration in your home country as the date for the protection in another country where you just follow with your application. But the rule of thumb is if you don't have if you haven't registered in a particular jurisdiction in Asia, as anywhere in the world, you don't have protection. So you can't really rely on your domestic trademark, for example, if you're dealing with, if you're producing something in China or you're entering the market, because sooner or later, if your product is successful, it will be copied. And if you don't have a trademark in such a jurisdiction, in particularly, I've seen a lot of cases like that in China. Not only you will have products which are copies of your products using your own trademark, but sooner or later you will have someone who will register your own trademark and who will then come after you and prohibit you from selling your product in China. Even though this is kind of like mind-blowing, but that's the reality. I was part of a initial litigation. We exactly this scenario happened to one Polish company there. I'm pretty sure that it's quite typical scenario. So you need to be careful. Trademark registration, yeah.
What happened in that particular case?
It's kind of like a long story. So we are back in beginning of the 1990s, and this is this boom for chip production in China. You have a Polish producer of clothes. They were focusing on the kids market, making very nice clothes for kids, and they figure out it makes sense to outsource the production to China. They started to do so with a local partner, and they were kind of like easygoing. The business model was to manufacture in China, bring it to Poland or Central Europe, sell it here, and have a nice margin because of the low production costs. And this model was sustainable until like 2005, I guess. And then they saw that the costs of production are going up in China. It's not really that attractive, and they were thinking about some other place to manufacture. But at the same time, they thought, well, there are more and more Chinese customers who want to buy their product. So they thought about offering or manufacturing somewhere else, and they've chosen Pakistan and selling it not in Europe but in China. I mean, and trying to position the brand as like a nice European brand and nice design, etc. And they were quite surprised when they found out that they cannot rent space in shopping malls because they would be infringing someone else's trademark using their own trademark in the layout of the shop and in branding the product. And then there was litigation, and they were quite lucky because the entity who registered the trademark was their former business partner. I mean, they had a number of cooperating manufacturers. I mean, they didn't. So they had two joint venture companies in different parts of China, which were running the factories, and their local partner from one of those joint ventures, they just registered the trademark, and I think they did it in a good faith, a long time ago. I mean, quite when they started operating, just in case, and they were the owner of the trademark. And they said, okay, you moved away with the production, we are left alone. That's, and the trademark is ours. And of course, then was, and they were technically right. I mean, we couldn't invalidate their trademark registration with showing that we had this registration in Poland earlier. I mean, it was the same trademark and it was registered earlier in Poland because we were not the first, so-called first to file in China. And the way, so we were really like in trouble, right? And of course we could buy the trademark from the former partner. But then it was a little bit sore. I mean, you can imagine that the managers of this Polish company were kind of unhappy with the whole idea of being negotiating with the terrorists, as they said. But they made their whole business model was based on assumption that they will be able to sell in China when they are not able to sell in China. They are not even able to rent a space in a shopping mall. That's quite amazing, because there was like injunctive order from the court based on the motion of the trademark owner. So we wiggled our way out, proving that they registered the trademark for us. So when we were partners at that time, we were running the same joint venture company, and it was proven by the correspondence and the witnesses that they offered to do that on our behalf, just because it was easier, basically, and it was a way of not really contributing to this joint venture, but like protecting the interests of this joint venture. But without this component, without proving that at that time we were cooperating and we actually told them to register it for us, and instead of mentioning our name in or having like a joint registration of the trademark, they limited only to themselves. That was the infringement, not really infringement of the IP right, but they didn't perform under the underlying contract with us, right? So they should have been loyal partner, and they should have been acting in a good faith. But this is a very typical story. Was just yet another story I will be happy to share with you, but probably a bit later, about a big Polish pharmaceutical company which got into very similar trouble, being blocked by their own joint venture company to actually sell their product in China. But this is a very, I think if you consider selling your product in China or offering services in China, it really makes sense to have your trademark or have the trademark under which you want to operate there, to have it registered. It's just, it's pretty simple as opposed to patent registration. Trademark registration is very simple, and it's quite cheap, I would say. I think you can, with the whole cost, with the translation and the representation of the local patent attorney, you can go down to something like 800 euros for the having the registration. So it makes sense, because then it gets really messy if you are not ready with the if you don't have this right secured. What I would like to do now is like go through the regulations in all the countries in question, and then discuss some case studies with you. The question is whether you would like to take a break now. Yeah, makes sense, like 10 minutes.